Lords, just before the short adjournment, I was expressing the submission that there was privity amongst all the employees in the bargaining unit and with the trade unions who negotiated their contracts of employment on their behalf. I don't want to go there again. But I just wanted to add to it that in our submission, it would be abusive on the footing that we were postulating there, namely that Mr. Reid had raised a mistake and succeeded on it in the tribunal. It would be abusive for other workers other than the Anderson claimants to pursue claims which were hopeless, in effect. It would bring justice into disrepute, and to take my Lord Justice Mayall's point, it would use unnecessary judicial resources. And Mr. Reid made reference to Rule 70 and 71 this morning, which give power to make an application to revisit an employment tribunal judgment. And it seemed to us that that rather made the point of illustration of the waste of resources and the abuse which that would occur if this hypothetical favourable judgment was challenged by successive claimants. Lord, we were examining, of course, this broader constituency in order to test the propositions. But I just remind the court, which is obviously in the forefront of your mind, what we're actually concerned with here is a strikeout by the Anderson claimants on the basis of the judgment that was entered in their case, which they say Nexus is
that right?
Is stopped from
I
pursuing.
thought the strikeout was being sought by the union.
I'm so sorry, my lord. Yes. Forgive me. What a bad point.
Always like an advocate.
Yeah. I'd hoped that lunch would have cleared my head, but it hasn't. Lord, a second point that I wanted to raise in relation to this is probably just as confused in this one, but to just examine a converse example. Assuming, let us assume for the purposes of the argument that Nexus refused to pay the non-Anderson claimants. That is, in fact, the position they have adopted. They refused to pay the extra payments. And they're then met by a series of employment tribunal applications, some lodged and some which have not yet been lodged. Now, if Nexus defend those applications on the basis that the letter agreement bears the construction which has been rejected by the Court of Appeal, clearly that would be an abuse, or issue is stopped. And it won't avail...
Why do you say clearly? Clearly the claim would obviously fail, and I suppose it would be struck out indeed. It could be struck out on the straightforward basis that the Court of Appeal has decided that that is not the meaning of this document, so the claim was hopeless and frivolous.
Yes,
and all the rest of it. It wouldn't necessarily be because it was an abuse. It might also be, but I think you shouldn't assume this would be the case, because that's the very issue we have now, that it would be struck out because of some Henderson abuse or because of issue estoppel. It might be, might not be. I mean, that's what we're here to decide. Then he advances the argument.
Whatever the mechanism, those cases will not be pursued and the judgment will stand. And the courts will not permit, in our respectful submission, a collateral challenge in subsequent proceedings to the judgment which has been established. And it will not avail Mr. Reed to say, oh, well, the judgment only relates to the past and not to the future, or for him to say, oh, they're different parties to those who were in the Anderson judgment, or that there's insufficient privity. Because in every case on this hypothesis, they're all workers within the bargaining unit relying on precisely the same terms in the contract of employment. Now, my lords, I turn from that to some, just a handful of particular points. They're not perhaps in the most logical order, but they are in some order. First of all, special circumstances. Mr. Reed raised a point on paragraph 35 of the judgment, which is in the core bundle at page 88. And it's the meaning of the last sentence. And I see the way he puts the interpretation. I have to say, until he's spelled it out in the way that he did, that's not the way that we read it. Sorry, it was 32, I think.
Yes.
It was the end of paragraph 32 on page 87. That's not the way we read it, nor 35. And the reason that we took the rather negative view of it is because of what was said in paragraph 12 of the judgment, which Mr. Reed did very fairly refer to. But I just remind your lordships, it's at page 83, the financial consequences of the Anderson judgment for the claimant are substantial. But the point that I want to make is either way, whether Mr. Reed's interpretation of paragraph 32 is right, and I'm sure on reflection he probably is right on that, but whatever it may, the learned judge had it in mind, the fact is that there will be financial consequences to one side or to the other, in fact, in precisely the same. What one loses, the other gains, and vice versa, to the penny. And of course, there will be more claims, and no doubt when the judge was thinking of the substantial losses, he had in mind not simply those that had accrued to date in relation to the Anderson claimants, but the ongoing future losses if Nexus were not to succeed in their rectification defence. And he may also have had in mind that there will be other claims for others within the constituency. But, my lords, we make the overall point, as I've made before, shouldn't really repeat, that financial consequences are an ordinary consequence of contractual claims and not special circumstances.
Isn't the judge really just making the point that we have to assume, for the purpose of these proceedings of this appeal, that the claim for rectification is a good claim? Now, I know you say that it's not, and that we'd be doing everybody a favour if it's a claim at birth, but we have to assume that it's a good claim, and therefore that rules are being invoked, whether cause of action is estoppel, issue estoppel, or abuse of process, to shut out what is in principle a good claim, which is worth a lot of money to Nexus, who, if they thought about it and got their tacking order at the right time, would have succeeded. That's the assumption on which we have to proceed. Isn't that really?
Well, I'm sure that's what he had in mind, indeed. But it doesn't alter the fact that that's not special circumstances, those are ordinary circumstances. Lord, next is a rather small point. Mr. Reed said this morning that Nexus were entitled to ascertain the terms of the contract and subsequently, after the Court of Appeal had given its judgment in 2018, the inequity of the trade union behaviour became manifest, and my Lord Justice Underhill made the point that if it was true, it was manifest when they advanced the case. And I wondered whether it was helpful just to analyse that a little bit further. It is in fact manifest in the claims which were put to the tribunal, because they relied on the trade union reading of the letter agreement, which the tribunal subsequently upheld, and again in the Court of Appeal. So having known that, the response of Nexus should have been, we say, and it goes to this point whether they should have raised it before, the response should and could have been, number one, the contract doesn't mean that. That's the construction point, even though at that time the Employment Tribunal jurisdiction to construe contracts of employment in this context was in doubt. And number two, the trade unions know that it doesn't mean that, and therefore the claimants are bound by the mistake which Nexus say that they have made. And there would not appear to be any doubt as to the jurisdiction of the tribunal to determine that. But that's an issue that we've already discussed. Lord, the next point I wanted to make was whether a collective agreement can be rectified. I won't repeat the short submissions we made in our written submissions, but we do say that the method, if the collective agreement is to be reformed, as they said in the 19th century, or rewritten or rectified, the means of doing that is to challenge it in the Employment Tribunal. That is well within the Employment Tribunal jurisdiction, as well as in the civil courts. And it's interesting to note that, of course, rectification, which we say, rectification is not a possibility in relation to a collective agreement, in relation to clauses in it which are inapt for incorporation, because since the collective agreement itself has no legal effect other than by incorporation into contracts of employment, clauses in the collective agreement which cannot be incorporated in the contract of employment neither can be enforced nor rectified.
That's probably right, and if Mr. Reid didn't formally concede it, he certainly indicated the position might be different as regards terms in a collective agreement which are merely collective in character.
Yes.
But this clause is not.
No, indeed.
So where does your point?
It simply highlights the proposition that it's not appropriate to rectify a collective agreement. Rectify a contract.
Okay.
Well, I'm just making the. Of course, sorry. Let me start again. Collective agreements are not enforceable as contracts. They only have effect by incorporation into contracts of employment. Since they have no legal effect other than through contracts of employment, we say they can't be rectified except in relation to contracts of employment. And that's merely illustrated by the proposition that if you've got a clause in a collective agreement which is inapt for incorporation, such as a dispute procedure or something of that kind. The leading cases, National Union of Mine Workers and NCB. Can't remember if your lordship was in that case or not, but
I was, yes.
and I wasn't. But
Rare.
But my lord, there are clearly terms in the collective agreement here which are inapt for incorporation. You can see one referred to in the letter agreement itself. It's at page 253 of the core bundle. It's not developed in any way, but it's clause 3 on page 253. Which says, under the heading Reduced Working Week, as I've explained previously, we share the common objective of agreeing a revised machinery of negotiation. Now, we don't know what that machinery of negotiation is. It's not in evidence. But clearly, that's the mechanism by which the unions on behalf of the workforce and the employer negotiated terms which did become incorporated into the collective agreement. Now, if there was a dispute about the meaning or whether there'd been some mistake made about the terms of the negotiation machinery, that wouldn't be susceptible either to enforcement or, we say, to rectification. But it's a small point. Lord, another small point is one that just to correct something that Mr. Reid said inadvertently. He said the letter before action proposed adding the employees to the unions for the purposes of the rectification proceedings. In fact, that's not correct. If your lordships look at supplementary bundle page 280, in paragraph 1.1, the author reiterates that in 2012, our client and your clients, the RMT, entered into negotiations, reached a collective pay agreement and so forth. And then in 2.1, we consider the appropriate defendants to any claim issued by our client for rectification would be all employees of our client to whom the 2012 collective agreement applies. In other words, everybody in the bargaining unit, but not the unions, apparently. But of course, they're entitled to change their mind.
Well, I perhaps didn't pick this point up at the beginning. So are you saying that Mr. Reid was mistaken when he said that their initial position was that they would proceed both against the employees in the bargaining unit and the unions, which I think is what he did say this morning? You're saying if you look at the letter, that is not what the letter was saying.
Yes,
I didn't.
Mr.
But can I just check that with Mr. Reid?
No, I realise I'm wrong. Now I look at it the 8th of January. My memory distorted, and I thought we'd said both, but we only said the employees. And then we obviously changed our mind before we issued proceedings.
Yeah. I knew it was an inadvertent error on Mr. Reid's behalf. No problem at all. Lord, I think there was one last point that I wanted to make, and yes, and it was in relation to the numbers. My Lord, we think that the numbers that Mr. Reid cited are on the low side. My instructions are that we believe, or RMT believes, that they had a higher proportion of the bargaining unit than 70%.
Okay,
but it's
that's
the
a more
ballpark.
indirect way of putting it. I don't think there's any dispute as to how many there are, so the real question is how big is the bargaining unit?
Yeah, but RMT had more members than are the Anderson clients, I think is perhaps what's being said.
Oh, sorry, it may be my fault, but can we just understand this? We were told, and this must be easily ascertainable, that there were 69 Anderson claimants.
Agreed.
I actually read somewhere there were 70, but I don't mind which figure is right.
Absolutely.
And that can't be in dispute. The real question is how many were there, well, the next question is how many employees were there in the bargaining unit? And Mr. Reid told us the full complement was 109 at the relevant time, though because of vacancies there were in fact only 97 at the relevant
Yes.
time.
Well,
Are you saying is that wrong?
My Lord, I'm not in a position to dispute that, and whatever the figure is, it's in that ballpark.
Okay, that's helpful.
My Lord, the only other point on the figures was this, that 114 claims, I think Mr. Reid told us, had been lodged so far, of which 6 were unite claims, and he thought that there were some non-union claims.
Yeah, he was pretty
What I can say is that all 114 claims are being handled by Thompson's, and therefore we believe that they're all either RMT or unite.
Yes, well,
And we wonder, in fact, whether there are any non-union claims at all for the...
Quite. Okay, that's...
So I'm not being at all helpful, but...
No, you are being helpful. And as I tried to say at the beginning, the precise thing doesn't matter, but it was, I think, important.
It gives your lordships a good picture.
Yes. Anything else? Well, is that it?
That's it, my lord.
Unless my lords have any questions. Thank you both for your succinct and helpful submissions, and those behind you who I'm sure have informed them. I should also say all three, because Stanley also made some succinct and helpful submissions. Those behind you, and well put together bundles, which is not always the case, so we're grateful for those behind them. And we will, of course, be reserving our decision. The usual procedure will be followed, under which judgments will be circulated in draft, so that we can have any typographical or other minor factual errors drawn to our attention, and so that the parties can agree consequential matters so far as possible, and if they can't, submit short written submissions. You will all, I hope, still be sufficiently frightened by Counsel General in Wales to appreciate the real importance of not using the draft judgment for any except the permitted purposes, which in turn affects the people to whom it may properly be circulated. A procedure is just about to go into force, but I don't think was followed for this appeal, under which we would ask for a definitive list of who the draft judgments should go to. I don't think we've done that in advance. Could I ask Counsel to put their heads together with their solicitors? But really, we would just like names of counsel and a responsible person in the solicitor. And we want actual individual email addresses, not clerks at or info at. And then we'll know exactly who's got it. We appreciate, I suspect, realistically, it will be circulated during the vacation, and counsel may not be around straight away. We'll obviously take that into account. But if you want to have a fallback address, by all means do that. I hope that made that clear. Could you send that in the next 24 hours?
Certainly, my lord.
Not that you will get the judgment in the next 24 hours. It means that won't be overlooked. Thank you very much.
Don't think